You're watching Newsfeed AM. Let's get into this discussion now. The Johannesburg High Court has found that the SABC's former interim board members had become mired in procurement processes at the public broadcaster. This is in relation to the awarding of a 185 million rand tender. This was for a security contract. Legal counsel for the former temporary board is Tebogo Malatji, who is in studio to explain to us what his clients, what happened at the time. Mr. Malatji, let me welcome you and thank you for making the journey here. Let me begin with this question. The former interim board members, were they explicitly aware that they were now meddling in procurement processes, which is what the court has ruled against in terms of their fiduciary duties?
Morning, Xoli, and morning to the viewers as well. I think the characterization of meddling is completely misplaced and incorrect. I think it's always important to go back to the era that we're talking about. So we're talking about June 2017, to be specific, 30th of June 2017. There's a board meeting. There's a recommendation made for the award of a security contract. As you know, the SABC is a national key point. And attendant in the board members' minds are a number of things. Firstly, who are they and what are they there to do at the SABC? I think you'll have read a piece written by Matata Tsedu in which he describes the prevailing circumstances at the SABC and the mandate which they were given as an interim board. And the SABC was then wrestled at that point in time and riddled by corruption and irregularities second to none. Now, with that in mind, they adopted, as you would have read from his article, what he termed a disruptive approach. So in other words, everything brought to their table is suspicious until cleared. And true to form, this particular tender was indeed suspicious, most importantly because a whistleblower had already told the chairperson of the board in a whistleblower report that, firstly, there is a relationship between the recommended bidder and certain of the SABC staff, and secondly, that there had been a tampering with records pertaining to that particular bid. And lastly, there was a report also that the tender had been cancelled twice before because the recommended bidder had been disqualified the last 2 times around. So immediately you can imagine these are people who were brought in to clean up the SABC and who have done so quite significantly. They terminated the Gupta Breakfast Show. They had done a whole host of other things to clean up. So that is what was before them when they were presented with a recommendation that says, here is successful bidder A versus 2 other bidders who were in contention. And it is in that context that they had to ask themselves, are we allowed in any form or shape to consider the second highest bidder if circumstances and the law permits? And in the room, let me just finish, in that boardroom, in committee, were 2 significant employees of the RAF. The one is the head of legal and the other one is the head of supply chain. And the advice received at the time is, if there are objective criteria upon which you can rely not to select the highest scoring bidder, the law allows you to do so. And they proceeded to examine whether there are such objective criteria existent at the time to deviate from what would ordinarily have been a decision to award the highest bidder. So it is far from meddling. It is in fact quite the contrary. It's an interim board that had to interrogate everything that's brought to it by way of recommendations, given what was prevailing at the time.
Based on what you've explained, this was an interim board determined to deal with corruption. Let's call it what at least Mr. Matata Tsedu wrote in the Sunday Times this past weekend. But here's a question. So they were determined to clean up. However, between these 2 bidders, and for viewers, for the for the benefit of the viewers, the SIU investigations revealed that Mjaeli Security Services was the favored bidder over Mafako Security Patrols, and that is who ultimately got the tender, this Mafako Security Patrols. But the difference between the two was that Mafako was 2.3 million rand more expensive than Mjaeli Security Services. Why would the interim board be in favor of a contractor who's more expensive than a contractor who obviously is going to help the SABC save money, which was, by the way, in a terrible state, as Mr. Matata Tsedu laid out?
Yeah. Regrettably, both the judgment of the court and the SIU ignores one significant proviso of the decision of the board.
Yeah.
And it was this: having considered all the relevant objective factors, A, the successful recommended bidder, well, the highest scoring bidder, has allegations of impropriety made by a whistleblower. 2, the difference in point scoring is the highest bidder is 99 points and the second highest bidder is 0.13 points lower. In other words, 98.87 points. 3 is we can't cancel this tender because it's been cancelled twice before and it's due to, the current contract is due to expire in the next month. And 4 is that Mafoko incidentally has a better BBBE scorecard than Mjaeli. But fourth and most importantly, and this is the condition that everybody ignores in the report, including the judgment, that in inquiring whether they have the power to consider to appoint a second highest bidder, they were advised Section 21F of the Preferential Procurement Policy Framework Act allows an accounting authority such as yourself as a board to appoint a second highest bidder, provided you satisfied yourself the objective criteria that's satisfied. So these criteria are attendant in their mind when they take the decision. So importantly, then they get to price. The price differential at 185 million is a minuscule 1%, right? But importantly, this is the important part. They take the decision on the basis that the SABC must conclude that contract on a price that is lower than what has been presented. In other words, on a price that is the equivalent of the successful, what would have been a successful bid. And that is minuted clearly in their minutes. Okay. So they didn't cause the SABC to incur expenditure of 2.3 million higher than would have been the case had they gone with a successful bid. Yeah. So that's the part that's not dealt with in the judgment. Okay. And neither by the SIU.
I want to quickly wrap up because we can get lost in the detail. But I think if the viewer is going to stay with us, it's important to understand why this board acted in the manner in which it did. Yeah. So here's what Mr. Matata Tsedu, who chaired, by the way, the Special Payments Committee, because it became clear that because money was tight, you had to rob Peter in order to pay Paul. So this is what he says, and I quote, "If we were going to wrest control away from the corrupt," that's a very important word, "we had to adopt the disruptive approach," exactly what you've spoken about. We had done it with our eyes open. We had done it with our eyes open. Guilty as charged, my lady. I suppose your clients here, without really belaboring the point, they are clear that they went beyond their call of being board members and they actually started making recommendations in procurement processes, and this is where they fall foul of the law. Are you saying that that's not how I am presenting it, or is it a terrible way of presenting it? Your clients are essentially admitting to guilt here.
No, he's been colloquial in that article. What he's actually telling you is that if he was given the job together with his colleagues, same job, same circumstances. In other words, you walk into a very corrupt and highly irregular procurement environment, you are required, he suggests, and that's what they did, to adopt this disruptive approach. So in other words, everything is suspicious until cleared. And remember, boards ordinarily have the power to award contracts of a particular value. So in other words, once in any procurement, supply chain management procurement in the public sector, there would be a threshold value which requires a board to take a decision. So each of these contracts that were brought before them had to be seen and reviewed and adjudicated by them from a disruptive approach perspective, because nothing was to be trusted as it was presented to them. So no, he's not pleading guilty in the literal sense. What he says is we've done a clean-up job in very difficult circumstances, and if he was placed in the same position, he would take the same decision again. And remember this, all of the objective criteria that I set out to you earlier on, if they prevailed here and now today, what he's telling you is he would still prefer the second highest bidder with these objective factors attendant than a bidder who's been implicated in a whistleblower report in circumstances prevailing corruption and or prevailing at the SABC at the time. And you see the saddest thing is then you have an article that appears in the city press that suggests that an employee was dismissed consequent upon this decision, which is factually wrong. I mean, the board members will still take guidance on what to do about that article. To give you an example, that particular employee was disciplined and dismissed 17 October 2018. That's a year and a couple of months after this board was no longer in existence. The disciplinary process has nothing to do with the security tender. It has everything to do with, reportedly, if you Google her story, you will find that reportedly she was guilty herself of tender irregularities. That's why she was dismissed. And she cleaned her computer. She wiped her computer clean. That was clean. And now these fine, outstanding citizens have an article that suggests that this person has been dismissed for blowing the lid. And that's very unfair reporting. The press code says you guys are supposed to be fair and factual in your reporting, and that article was far from it.
Okay. Final question. The reality for your clients, these former board members, is that they face the prospect of being declared delinquent directors, and what that carries is a ban from being a director of any company for at least 7 years, or it could be far worse. It would be a ban for a lifetime. What happens now?
You see, again, regrettably, both the court and the SIU have not had regard to Section 162. Under what circumstances can a person be declared a delinquent director? So Section 162 of the Companies Act tells you they must have abused their position as a director. They must have personally gained out of that conduct. They must have grossly breached their trust, their fiduciary duties as a director. None of these circumstances are prevailing. None whatsoever. You read the SIU report, you will find it absent in saying fact A, this is what the board has done, therefore equals a contravention of Section 162 sub 5A, which is that they have abused their position, or B, that they have personally gained out of it. So none of that is existing. In the same way, by the way, that
you're not telling me, I'm fast running out of time, you're not telling me whether these members are going to go and challenge the outcomes of this court process, which threatens to make them delinquent directors.
Well, here's what the court said. The court says the SIU report doesn't say that. The SIU report is an opinion which, if accepted by the SAB board, will result in an application for them to be declared delinquent. So until the SABC acts on the recommendations of the SIU, there is no decision for them to be worried about. We took the decision on the basis that it's got an external effect on them. You and the other public are sitting here saying the SIU says they're delinquent. The court has now pronounced and said, no, all that the SIU has said is, in their opinion, the directors are delinquent, but it is up to the SABC to act on it. So our clients currently are taking the matter under advisement in the sense that the judgment says they shouldn't have complained about the SIU report and its finding because it is nothing more than an opinion and a recommendation. And so we're taking the matter under advisement on that basis.
All right. Tebogo Malatji, lawyer representing the former interim board members at the SABC. Thank you very much for your time.